Okay, in the next section of our video vignette series, with regard to the KYR statewide contract, we're going to talk about the closing section. Now, this begins on line 184, which again, those numeric numbers on the side, the left-hand side of the document, and it runs down to section or line number 228. We're going to start with paragraph 12, which is the closing date. And it says that you only get to choose one option. And you're presented with two options, option A on 186 and option B on 189. Now, they look different, but what we're going to find out is they are remarkably similar. So option A says that the closing of the transaction shall occur on a specific date. So let's assume that you were to put in there March 31st, 2021. And it goes on to say, unless otherwise agreed upon in writing between the buyer and the seller. So that says that you put a set date down there, again, March 31st, 2021, and that you can change that date. The agents can talk to each other, they can move it forward, they can move it back. But when they do it, they need to make sure they do it in writing or it won't be enforceable. And that's an important thing to remember, and it is a requirement that they have it in writing. And this could be important down the road if there becomes a controversy. Now, it goes on to say that the closing time shall be agreeable to both buyer and seller, which agreement shall not be unreasonably withheld. Well, when we say the closing time, what we're specifically referring to is the hour or half hour or 15-minute increment of when this will occur. So we're going to say March 31st, 2021 is the day we want it to occur. And then the buyer wants it to occur at 9 a.m. And let's say the seller wants it to occur at 3 p.m. Well, in all likelihood, what does that mean? It probably means that the closing is going to occur at 3 p.m. because the buyer, if they're ready at 9, is by inference going to be ready at 3. And the seller who says, I don't want to do it until 3, is probably going to have their way because there's really no way to force them there. It's hard to say that they're unreasonably withholding it to get in front of a mediator, to get in front of an arbitrator, to get in front of a court, to compel anything. So truthfully, the most intransigent person, the person holding out for the later time, not date, will probably get away with what they want. Now let's go to section B or option B, and that says the closing of the transaction shall occur no sooner than blank days nor later than blank days unless otherwise agreed upon in writing between the buyer and seller. So now, conceivably, it appears you're not looking at a specific date, but you're looking at a period of time. So if let's assume that 30 days took you to March 1st, 2021, and 60 days took you to March 31st, 2021. Remember that date again. So this says that if you want to close, you can close somewhere between that time period. But here's what it goes on to say. It says the closing date and time shall be agreeable to both buyer and seller so long as date is within the time frame. So let's say the buyer wants to close on March 1st, but the seller says, I want to close on March 31st. You've got this problem there. And then it says goes on to say if the buyer and seller cannot mutually agree upon a closing date and time, closing shall occur on the last business day of the time frame. What did we say was the last business day of the time frame? It's March 31st again. So the first option gives you a specific date. The second option gives you a period of time, but the only date that's really solid is the last day of that period of time. So the parties need to recognize that it implies a negotiated time frame, but they really need to be thinking in their head, this may not occur until the very last day of that time frame. Now, the next part we're going to talk, and one last thing to talk about on that. I get a lot of calls on this because maybe the buyer's not ready to close or the seller's not ready to close. And people call me and they say, well, what do we need to do to make this happen? Well, you need to persuade the other side because the likelihood of you getting a court or a mediator or arbitrator or somebody with any power involved to compel a closing like that within a certain number of days is nil to none. So really it goes more to negotiating. Now, if the time period gets too far out, you're really, again, going to be looking at potentially suing them. But in all likelihood, it's not going to be to get them to sell it or come to a closing. It's going to be get them to sell or buy it and come to a closing. It's going to be going after them for damages as a result of them not closing. And when I say damages, I mean money, as opposed to trying to get the closing to actually occur. And that would require injunctive relief or special relief. And in legal terms, that's really hard to get. Now let's talk about the next section, which is date of possession. It gives you the choose only one option. This is on line 194, and it says possession of the property shall be given by the seller to the buyer, either A, simultaneous with closing, with all keys at closing table and property ready for occupancy. That is the most common and the smoothest from a legal point of view. Now, the next option is on line 196, and it says by a certain time, being determined by the local time of the property location, and a certain number of days after closing, closing date not included. Wow, I really hate post-closing possession because it creates a whole slew of potential problems. It creates problems from the buyer's perspective because they are not in the property that they have told the bank they're going to be in. It creates a problem on what if the people that are in possession after the closing don't leave? How do you get them out? Is it an eviction? Is it a foreclosure? What exactly is going on? If they're leaving, is it rent that they owe? Is there some sort of penalty? Because in Kentucky, penalties are not allowed. They're against the law. It creates a whole slew of conditions that you want to avoid. So anytime you deal with a post-closing occupancy or / possession, I think you need to tell your client they need to talk to a lawyer and they need to get an agreement of some kind after a discussion with that lawyer. That is something that you should not prepare, nor should you incorporate within your contract. That should be done by an attorney because it creates a whole slew of legal issues. And again, I am always against, if you've heard me speak before, I am always against pre-closing possession by a buyer. It creates a world of problems and can result in you not being able to evict a buyer who won't close, but instead having to foreclose against them. And that could be a really long time, and you will have a really angry seller for you allowing them to get into that position, even though arguably it's not your role to stop them. The next section we're going to talk about is section 14. That's condition at possession. That begins on line 197. Now, the important thing about this is that when the seller leaves the property, they're supposed to have it cleaned, all the trash removed, and broom clean, meaning there shouldn't be junk and papers and things all over the place. And personal property that wasn't mentioned in the contract to stay or by a separate agreement, written agreement to stay, they need to take that out. And any damage that they do taking out personal property needs to be repaired in a workmanlike manner. So what do I mean by that? Let's imagine that they are supposed to take the wall mount and the TV out of the property, and that was agreed to. If they take it out and they rip out the drywall and they just slap some tape over it, well, that's not good enough. Now, somebody may say, well, but Jason, if you close, all prior negotiations merge into the deed, and so you're not going to be able to close and then go sue them. Actually, I think you probably can in this situation, because if you notice at the end of paragraph 14, it says this paragraph shall survive the closing. That means even after a closing, if there was a breach of this paragraph, the purchaser could go and sue the seller for that breach, whether that be in mediation and arbitration or in court if that's not available to them. The next part we're going to talk about is the walkthrough. Now, the buyer shall have the right to perform a walkthrough inspection prior to closing. And it goes on to say, and again prior to delivery of possession to verify condition, and that this paragraph shall survive the closing. So now let's talk about that. So obviously right before the closing, the buyer can say, hey, I want to come in, I want to look at it, I want to make sure it's all right. That's fine. But let's say at the same time, they're not actually going to get possession of the property at the closing date because option 13B was chosen. That means that they can come back when they do get possession and do another walkthrough and look at it and make sure that everything's okay. Now, in both circumstances, if they see something that they don't like or their right to do it is being prohibited by the possessor, that would be the seller, even after the closing, they can sue over the loss of that right. And that raises, again, a whole slew of legal issues. But understand that that means that their rights are not foreclosed upon as it relates to that. Now, let's drop down to the next part, which are warranties on transfer. Now, that's paragraph 17, starts at line 212, and it says that the seller agrees to transfer to the buyer at closing seller's interest in any manufacturer's warranties, service contracts, and other guarantees or warranties which may be transferable to the buyer. Now, should there be a fee for this transfer, it shall be paid by the buyer. Now, let me give you some recommendations on this. First, if you're the listing agent, you should have a checklist of what all of these are as soon as your buyer makes an offer on the property, or maybe even before, so that you can say, hey, look, all of these warranties are going to come with it. Here's a list of them. Here's which ones are transferable, and here's what they cost to transfer. If the listing agent doesn't have that, my recommendation to the buyer's agent is that you go to the listing agent and say, I want to know all this. And you have a checklist that the listing agent fills out. Now, what both agents should be doing at the closing is making sure that actually happens. A lot of times you may have the seller may be able to transfer the warranty, but there may be a set time frame to which to do it, whether it be 30 days, 60 days, 90 days, whatever. And if a listing agent or a selling agent does not do that, does not get that transfer to occur, there may be some liability there. So we want to make sure that we have a checklist on both sides and that is done at the closing and all of the warranties are transferred at that time. This also ensures that you limit any liability you may potentially have. Not saying you do, but if you do have it, you're limiting it by making sure you're sliding that across the table and now it's the other side's problem. Finally, we're going to talk about the last part that I think is important to note, and that is paragraph 18. Now, this talks about what kind of title will be conveyed at the closing, and more importantly, it talks about the owner's title insurance policy. Now, I could do a whole hour on unencumbered marketable title and difference between different warranties, general warranty, special warranty. But to a large degree, a buyer really doesn't have to worry about a lot of those issues if they get owner's title insurance. And the default provision in paragraph 18 requires them to get it. That means that if they sign this contract, unless they opt out of purchasing owner's title, they're required to get it. Now, people will sometimes say, well, when I go to closing, my buyers didn't opt out of it. They're just going to go ahead and not pay for it. No, they have to pay for it once they've signed this contract and the seller is also signed. There's not an option, and the closing attorney must get it done, or the closing agent must provide it unless they get the consent of the seller. Why do I say that? Because the seller is going to encourage owner's title insurance, because that is meaning that if a problem does arise, it is less likely that that is something that they're going to be responsible for, and that insurance is in fact going to be responsible for that. Now, the insurance company sometimes can still go after the seller, but it does potentially limit claims that the seller will have to deal with, and it puts it off on insurance. So the failure to purchase that insurance is not a choice the buyer can make once this contract is signed. So I encourage you to get owner's and title insurance. I've done title insurance defense for years. I've seen what it can cost when you don't get it. So I would encourage you to recommend to your clients that they just sign this and they go ahead and get owner's title. This is the time to get it. This is the least expensive time to get it. Any agent that recommends to their clients that they opt out of the purchase of owner's title insurance, I think is doing their client a disservice. Now, the next section that we're going to talk about deals with the notices and finally with mediation and arbitration. That'll be the next part of our video vignette series. If hopefully this can be helpful in your use of the Kentucky REALTORS statewide contract.